Speaker of the House has requested consultation from the Rules Committee on a point of order raised on the House floor Tuesday regarding Senate Bill 2. The question presented to the Rules Committee is this: Did the Senate pass Bill 2? Did Senate Bill 2 pass the Senate with the required number of votes, and is it therefore properly submitted to the House? The only question before the Rules Committee in regards to Senate Bill 2, this bill is not before the committee, so we're simply debating if it was transmitted properly. We are not here to debate the guts of the bill. I just want to make that very, very clear. So anyone in the audience who's going to be speaking for or against this bill, please keep your remarks to that, not the information on the bill. We'll begin testimony with Representative Nichols, who raised the point of order. Representative Nichols, you are now recognized.
Thank you, Madam Chairman, and I'd like for my counsel here to introduce herself to the committee.
Katie Bodenhammer. I'm an attorney with the Catholic Law Firm.
Okay, we're here today to consider an issue that probably hasn't faced the Rules Committee in the past, and that's whether Senate Bill 2 requires a simple majority or a super majority. Our position is it requires a super majority. Now we're getting into issues that are legally complex. I think the Speaker said that neither side would be kicked out of court based upon our arguments. So we both have valid arguments, and you will hear why we think it requires a supermajority, and I'm sure Senator King's team will argue that it only requires a simple majority. And you're here to give your opinion on that issue. So I'll go ahead and turn the mic over to Katie, and she can lay out basically our legal argument.
Well, the basis of our legal argument...
If you would please, before you begin, will you state your name here for the record?
I'm sorry, I'm Katie Bodenhammer, and I'm an attorney with the Catholic Law Firm.
Okay, thank you. You're recognized.
Thank you. The basis of our argument is that Senate Bill 2 would require a supermajority in both chambers to be enacted pursuant to Amendment 51 of the Arkansas Constitution. Amendment 51 fixes the qualifications for the voters in the state in direct, positive, and affirmative terms. And these qualifications cannot be added by a legislative enactment without a supermajority of both chambers. In fact, the express purpose of Amendment 51 is to establish a system. I'm sorry.
I had a document. Is that the permission of the chair?
Yes, she just passed it out.
Okay, thank you.
Okay, just quickly to Amendment 51's purpose, and that's to establish a system of permanent personal registration as a means of determining that all who cast ballots in elections in the state are legally qualified to do so. In other words, Amendment 51 establishes and fixes the qualifications for voters qualified to cast votes in the state of Arkansas. Among the list of those qualifications, when registering to vote, a voter must present either a current and valid photo identification or a copy of a current utility bill, bank statement, government check, or other government document that shows the name and the address of the voter. Once that voter has proven his or her identity is with one or two of those documents, it is unnecessary for such voter again to register unless such registration is canceled. Therefore, once that voter has registered, he or she is qualified to vote in any election in the state and cannot be required to re-register, cannot be held to give over additional documentation absent a new constitutional amendment or legislation enacted by the General Assembly. Now, regarding legislative changes to voter qualifications, Amendment 51 sets forth qualifications for voters, but it also allows for the General Assembly to change those qualifications upon a 2/3 vote by each chamber. Senate Bill 2 requires voters in the state to present a current and valid photo identification at their polling place at the time they're casting their vote. They're not allowed to bring in a current utility bill, bank statement, government check, or other government documents to prove their identity. This requirement is beyond the bounds and the explicit verbiage of Amendment 51, and thus the bill is imposing an additional requirement in order for voters to cast their ballots in the state. The argument that Senate Bill 2 does not invoke or specifically reference Amendment 51 or even the Constitution because it doesn't reference the amendment or the Constitution, that it does not trigger the procedural requirements under Amendment 51 is problematic. Simply because a bill that purports to amend the Constitution yet does not make a specific reference to the Constitution is irrelevant. The question to ask is whether or not the bill is in effect amending the Constitution. And because Senate Bill 2 is adding a qualification beyond the bounds of Amendment 51, it's in effect changing the Constitution. And really, I think that's kind of the basis of our argument, because Senate Bill 2 clearly intends to add to the qualifications required under Amendment 51. Absent a 2/3 affirmative vote by each chamber, the bill may not be enacted, and to find otherwise would be in direct contradiction to the procedural requirements found in Amendment 51.
We'd be willing to entertain any questions this time.
Representative Burris, you're recognized.
Thank you, Madam Chair, and thank you for the testimony. You're both attorneys and pretty good ones that, I hesitate to even begin to question. But let me tell you, kind of, in preparing for the committee, when I read Amendment 51, came to some of the same conclusions as you. But you testified about Amendment 51 setting up the parameters for permanent personal registration. Did I repeat that correctly?
Yes, sir.
And so, to a non-attorney, and hopefully to an attorney reading that, I think setting up, I don't think we're affecting the permanent personal registration requirements that are clearly outlined in Amendment 51. We're actually just mirroring them in terms of the photo ID requirement, in terms of voting, but that's really even besides the point. The point would be Amendment 51 deals with registration, which this bill does not address.
Well, actually, Amendment 51 deals with permanent voter registration. So once that voter has registered, they are permanently registered for the duration of their voting career, I guess. So that to require a voter when they show up at the polling place to only provide photo ID, to not have that option to provide the government check, the utility bill, the water bill, and whatnot, is in contradiction to Amendment 51. It's adding another qualification. They're already qualified to vote when they're registered.
Do you believe that our current qualifications in terms of presenting ID violate Amendment 51?
No, I do not.
Why not?
You mean at the polling place?
Right.
Well, you're not required to produce identification. They ask for it, but you're not required to.
And I guess again, the point is, Amendment 51 deals with registration, and you said that ID is required for registration. Is that correct?
Either a photo ID or a utility bill, water bill, things like that.
So my 2 points are very simple. One, this bill does not address the requirements of registration laid out in Amendment 51. It addresses voting, which is separate. But even if you agree that it did, the threshold that we're placing for voting is no different than the threshold placed on registration through Amendment 51. Is that a fair statement?
I don't believe it is because
a photo ID is required for registration.
or a utility bill,
Right.
bank statement, things like that.
But that comes back to my original point, and I think where, I guess the bottom line question is, I mean, I understand your legal theories and the argument, but can you definitively say that the ID requirements in this bill fall under the Amendment 51 requirement?
Yes. Okay.
Thank you.
Representative Williams, you're recognized.
Thank you, Madam Chair. Thank you, Representative Nichols. And Ms. Bohammer, let me direct you to Section 19 of the amendment and try to stay on the procedural issues, not necessarily the substance of the bill as we're required to do here. Section 19 of Amendment 51 lays out the requirement for the General Assembly to amend this act. And it uses the term that so long as such amendments are germane to this amendment and consistent with its policies and purpose. If we're to believe that I have to explicitly say that I'm amending sections 5 through 15 to actually amend them, what would be the reason for using words like germane or consistent with? If it was really just, literally just, you have to say that I'm amending 5 through 15 in my bill. My question makes sense to you?
Well, can you, rephrase it just a little bit.
As I understand the arguments is that if we're not saying that we're amending sections 5 through 15, then we're not amending section 5.
Okay.
So if I pass a bill, that said, for example, only good-looking men wearing red ties and sitting in this seat can register to vote. And I don't say that I'm amending sections 5 through 15. I'm just the bill, and I'm lucky enough to get 51 people to agree with me on that. Then under the theory that is defending this bill, then that would be valid. Is that not correct?
Well, once that bill was taken by the court, no, it wouldn't be valid because you violate the provisions of Amendment 51. You didn't meet the 2/3.
And is that because it's germane to 51?
Absolutely.
And so even though I don't say I'm amending sections 5 through 15 in my bill, I may pass a separate act that amends some other section of the code. As long as it's germane to 5 through 15, you believe it requires 2/3 vote?
I do. I believe it triggers the procedural requirements of Amendment 51.
Thank you.
Representative Gillum, you're recognized.
Thank you, Madam Chair. If you might go back a little bit in your opening comments, help me clarify something here. You talked about how Amendment 51 was about registration, and all the provisions that I've looked at here, really concerned about registration and transfer of registration, cancellation of registration, everything. Can you clarify how exactly that what someone does at the polling site is the same as registration? Is it the same function? And are you testifying that every time we vote, that is a function of the registration?
Well, Amendment 51 sets forth registration requirements. Once you become a registered voter, you are permanently registered. Therefore, you don't have to meet any other additional requirements to cast your ballot. And so, no, I don't think necessarily the polling place, they need to ask for photo ID, water bill, things like that. You're allowed to, so long as you give the voter the option, the same option that they were given when they were registered to vote.
Okay, but I'm not, okay, maybe I didn't articulate that, and I apologize, Madam Chair, for my follow-up, maybe try this again. Is what takes place at the polling site, regardless of what's offered or whether, they ask for it or it's mandated or whatever, is that a direct function and correlated to the act of registering to vote?
Yes, I believe so. When at the polling place, we're talking about voter qualifications, whether or not you're a qualified voter.
Qualification is different than registration, is it not?
No, actually, no, you become a qualified voter when you register to vote.
Okay, so you're already qualified when you register, correct?
Well, upon registration, you are
Upon
a qualified
registration,
voter.
you're qualified.
Yes.
Okay, so then somehow you become unqualified, how? Can you explain that to me?
You don't become unqualified, you're permanently registered to vote once you've registered under Amendment 51.
So nothing you do at the polling site would unqualify you?
If you're convicted of a felony, you're no longer qualified. If you move out of the district, you're no longer qualified. Those types of things would take your qualifications away.
Those would, okay. But just showing up to vote, you're still qualified to vote, and not engaging in any of those other activities, you don't lose your qualification, correct? Unless you move out of your district or you're convicted of a felony. You don't lose your
I believe that's
qualification.
correct, yes.
Okay, all right, thank you.
Representative Williams, you're recognized.
To follow up on Representative Gillum's line of question, let me present a scenario. I'm a 75-year-old woman who doesn't drive, don't have a driver's license, but I do have a utility bill. And I go down and I register with my utility bill. And if this, let's say this bill has passed, I go to vote. I don't have a photo ID, but I still have my utility bill. Can I?
I'm going to point of order. Representative Lee, you recognize me.
Well, actually, I actually haven't discussed the motion because I'm referring to exactly what Representative Gillum talked about, because I'm talking about the qualifications of registration, whether this requires 2/3 of 51, because you can be registered, as Representative Gillum just talked about, without a photo ID, but then not be able to vote at the poll. Is that not correct?
That's correct.
And so, would you not agree that that is germane to this amendment?
Absolutely.
And may not be consistent with policy of this amendment, but clearly it's germane. And if it is germane, then would it not require a 2/3 vote?
Yes, you're correct.
Okay, thank you.
Representative Clemmer, you're recognized.
Thank you, Madam Chair. It seems though like we're arguing that once you have registered to vote, you no longer have to show that you are who you say you are. I mean, the idea of the registration, I mean, that to me seems like you've taken a driver's test and now you have a driver's license and then the policeman pulls you over and they're supposed to take your word that you are who you say you are. Because you have, of course, I mean, I know the law requires me to carry it, but I mean, it seems like the same principle. I have taken my driver's test, I have qualified, and now law enforcement is supposed to ask me, I mean,
I'm getting lots of
Okay.
point of order, so
Okay.
again, we're just referring to.
all right,
whether or not
I mean,
it's-
but I guess but I think we are all trying to get around this, are we registering? You know,
Right.
Or are we not? And that's, and so my analogy was,
Right, and members behind me, I'm gonna be a little leeway on the point of order because this is such it's a thin line, as we all know, it could go either way on this, so I'm gonna be a little bit more lenient if that is okay with the committee.
we are registered and qualified as drivers, and yet we still have to show proof of that. And so I think that's what we're all hung up on, is that we're not considering it that you are registering. We're just saying you have to show that you are indeed the person who did register.
And, I mean, not to get into the merits of whether or not that should be a requirement, but under Amendment 51, you can show your photo ID or a water bill, a bank statement, things like that. I think to be complicit with the intent of Amendment 51, then you should have that option at the polling place to show either a photo ID or the bank statement, utility bill, as provided under Amendment 51, since you have that option when registering to provide one of those documents.
Representative Burris, you're recognized.
Thank you, Madam Chair. And I think getting to the heart of the matter, we're basically discussing whether or not the county registration and the same qualifications apply to the actual act of voting. You would agree that state or local jurisdictions have the ability to place some restrictions on the act of voting.
Yes.
And so I think the fundamental difference that we're going to hear from testimony from other attorneys that differ with the two of your legal opinion is that this falls under the ability of a state or a county to limit the act of voting. No different than my Amendment 51 privileges aren't. Just simply because I'm registered doesn't mean I get to vote whenever I want, wherever I want.
Right.
I'd vote within a time frame allowed by the county in a specific location prescribed by the county.
Well, the specific location, specific time, that's not prescribed in Amendment 51. What is prescribed in Amendment 51 is that upon registration, you have to show either a photo ID or the bank statement, water bill, things like that. Because Senate Bill 2 is adding an additional requirement to that qualification, saying that you can only show photo ID when you show up to vote, it's in effect imposing an additional voter requirement in order to be qualified to cast your ballot. The only thing we're saying is that, this is specifically, I think, in contradiction to the explicit language of Amendment 51, and therefore it just takes a 2/3 vote by the legislature
Right.
to change that
I've
up.
got a saying in Harrison that you can waller a possum hairless, and so I'm not going to do that because I think we're going to have some attorneys come up and give a different opinion. And I think it all comes down to the interpretation of whether or not Amendment 51 addresses the act of voting or the registration of voting, which again, quoting from your language directly from Amendment 51, addresses the permanent personal registration. And I view those as two separate things, even though I understand the legal argument that maybe it's not. I think there's going to be a legal argument made in a minute that says that it is. Thank you.
Curious, Representative Burris, have you ever wallowed with the possum? Just curious. Representative Williams, you're recognized.
Thank you. Back to my 75-year-old example, because that's my mother, actually, before she passed. She never drove and didn't have a license, but always voted. If you register to vote using something other than a driver's license, your water bill, your bank statement, and you are qualified to vote, when you get to the polls and you don't have a photo ID, would you, under this bill, would you be allowed to vote?
I believe you would be allowed to cast a provisional ballot and then show several days later.
And I've got to come up with some kind of photo ID. So the act, practically, your registration, unless you somehow get a photo ID, is meaningless. Because unless you have a photo ID, you're not going to be allowed to vote. Is that not correct?
Absolutely.
So the clearly adding a photo requirement is an additional qualification for a qualified elector, or clearly it's germane to Amendment 51, that's requiring 2/3 vote. Is that not correct?
Absolutely.
Thank you.
All right, seeing no further questions, thank you. At this time, I'm going to ask Dan Greenberg to come up and speak against the motion.
Thank you, Madam Chairman.
Wait, is your mic on?
Thank you, Madam Chairman. My name is Dan Greenberg. I'm with the Advance Arkansas Institute. And if I may, I'd like to make 3 points that I think are relevant to this question. The first point I'd like to make is about the nature of amending the Constitution. There are really only 2 ways to amend the Constitution. One is you can have a vote of the people, and the other is that the legislature can amend the Constitution through a 2/3 vote in certain areas. And of course, Amendment 51 creates this procedure for amending the Constitution with a 2/3 vote. The way this works is that when the legislature casts a 2/3 vote to amend the Constitution, this adds text to the body of the Constitution. And so it's troublesome when we hear a presentation about how we're going to have this SB2 and it's relevant to Amendment 51, because it's not. SB2 is a bill that proposes to add language to the Arkansas Code. It is not a measure that's going to add text to the Constitution. And so when we talk about this 2/3 requirement with respect to SB2, it's really apples and oranges. It really doesn't make any sense legally. Passage of SB2 does not change the Constitution. It doesn't amend the Constitution at all. It's a bill, it is not an amendment. And so bringing up the 2/3 requirement with respect to SB2, in my view, is really kind of irrelevant or even confused. The second point I'd like to make is that it's difficult or impossible to argue that SB2 changes voter registration procedures at all. In fact, if you look at SB2, there are really only 2 places where you can argue that it does anything at all with respect to voter registration. In Section 3 of SB2, the bill changes the code references and the numbering, kind of like signposts, but it doesn't change the substance of the code at all. And in Section 4, there's language that changes the regulation of voting, but it doesn't change the registration procedure. And so the argument that either of these provisions changes voter registration, which is the subject of Amendment 51, is very weak. In the case of Section 3, I think it's completely empty. Now, my third point, really, I'd just like to say something nice about Representative Burris, who is, of course, leaving the room. But there are kind of two different legal theories that we've heard expressed with today. We've heard the idea from the people who are sitting here before that this is somehow an additional qualification for voters. And we've heard an idea that, from Representative Burris, that this is very different from additional qualification. And what I'd say about that is that, by and large, the courts agree with Representative Burris. And so, although he says he's not a lawyer, and he pretends not to be a lawyer, he's actually making the case that, in my view, the majority of courts in other states have found. And I'd like to say a little something about that, if I could, because it's important to look at the distinction between imposing an additional qualification on voters and creating a test that determines whether a qualification is met. Because if you look at the majority of cases that have looked at voter ID in other states with very similar constitutional provisions, particularly if you look at the Georgia Supreme Court and the Indiana Supreme Court, they didn't find that creating a voter ID requirement creates a new qualification. In fact, they found that it creates a test that measures a qualification. Georgia's constitution, like Arkansas's, permits all citizens with constitutionally specified qualifications to vote. The Georgia Supreme Court noting that the legislature could come up with reasonable regulations that govern how these qualifications would be determined or tested, upheld voter ID. Similarly, for Indiana, the state's constitution creates a limited set of qualifications, just like Arkansas's. And in that case, the plaintiffs argue that voter ID impermissibly creates a new qualification. The Indiana Supreme Court disagreed. Now, what the court said in Indiana is that an ID requirement doesn't create a new qualification. It rather functions merely as an election regulation to verify the voter's identity. And the court echoed a similar previous finding from federal court. Now, that in my view is the majority opinion across the majority of states that have examined this proposition. So those are the three things that I would say about this. And speaking generally, I think that the idea that we're amending the Constitution by means of legislative code doesn't really make any sense. The only way for Amendment 51 to operate is if you amend the Constitution with new words in the Constitution. This doesn't do that. So legislation doesn't apply to Amendment 51. Only putting new words in the Constitution applies to Amendment 51. Having said that, I'd be happy to take any questions.
Great, thank you. Thank you, Representative Greenberg. It's always good to see you back.
I'm a free man.
Yeah. Representative Williams, you're recognized.
Thank you, Madam Chair, and I want to echo the chair's sentiment. It is good to see you, though we see you a lot, but it's good to see you. Just didn't realize you left.
It's hard to stay away from so many friends, Representative Williams.
Let me talk to you a little bit about your theory that you actually have to be amending the actual Constitution to do that. So if that's true, then if we passed legislation that said that, for example, in Section 5 of Amendment 51, it says that the Office of Driver Services and the state revenue offices have to provide voter registration forms. That's in the Constitution. If I passed a bill that said driver services and state revenue offices shall not provide voter registration forms, do you think I would be amending the Constitution if I did it by statute, not touching this Constitution provision?
So if I understand your question, you're asking, if the Constitution says you must do A, and then you pass a statute that says you can't do A, are you amending the Constitution? No, sir, I'd say you're violating it.
I think I'm violating the Constitution. I'm not amending it, though.
You certainly aren't. And you know, my opinion on this is largely based on Section 19 of Amendment 51. And Section 19 just says the General Assembly may, in a certain manner, amend Sections 5 through 15 of this amendment. It doesn't say expand on the meaning of. It doesn't say kind of amend, which is kind of the previous argument here. It says they may amend Sections 5 through 15 of this amendment as long as such amendments meet certain tests.
And so in your definition or your theory, to amend it, I actually have to say that I'm amending 5 through 15. I can't.
Not exactly. I would say in order to amend the Constitution, if you're going to amend the Constitution has to be different after you amend it than before. I mean, that's what amending the Constitution is. You add words to the document. I mean, that's what amendment means.
Right, so the language in Section 19 that talks about amendments being germane, do you think that, how do you reconcile that with your point?
Well, that's a test. That's a test about certain, because you couldn't amend Amendment 51 with legislation about amusement parks or trucking regulations. You can only amend Amendment 51 with respect to voter registration issues.
Okay, so similar to Section 15 where it deals with penalties, I think it sets a felony for someone who intentionally destroys the voter registration. If I lower that to a misdemeanor, I'm not amending Amendment 51. If I did it by statute, I'm not amending 51.
I mean, I don't see how you could be. I mean, the First Amendment says you have the right to petition your government. So if you pass some sort of statute that says we don't have the right to petition our government, no, you're not amending the Constitution. You're just violating it.
And let me ask you, the very purpose of Section 51, this permanent voter registration. What's the purpose of registering? What's the purpose of it? Why do we have it? Is that not so you can actually vote at some point in time? You register so you can vote. Is that not correct?
Well, I mean, the purpose that I personally would have to register would presumably be to vote later. The purpose of having a voter registration system as a general matter is to provide order to the process and make sure we preserve people's constitutional rights. I mean, it's a large question, obviously.
But clearly most people do that so they can go and vote.
Sure. That's the reason many people register. Sure.
Right. And so if I register with my water bill or my bank statement, and we pass it into 51. And I get to the polls and I don't have voter ID, then I would not be allowed to vote. Is that not correct?
If you register with the water bill,
and I don't possess the same pipe I've been using. I don't possess a photo ID. I register with my water bill. I don't possess a photo ID, though I go to vote in section, and we have passed
Well-
Senate Bill 2 that I'm not allowed to vote.
Well, you'd be allowed to vote under SB2's procedures, which involve a
Right,
provisional ballot.
Right, I don't have ID, so I can't go back before that Monday and give you ID. I don't have ID.
Well, of course, and I don't want to violate
Well,
the
she's
chair's
given-
rule
she's
about
given-
discussing SB2, but of course, there are procedures if you don't have an ID under SB2 and involving discussing the impossibility of getting an ID and so forth. I'm hesitant to accept your summary of it because I don't think it's
Okay,
technically
well,
correct.
my larger point obviously is that the very purpose of registering is so you can vote, but yet SB2 seems to clearly add an additional qualification because I can be qualified under 51 to vote.
See,
But then
I-
I'll finish. But then when I get to the polls, I'm not qualified because I don't have a voter ID. And you cite Georgia and Indiana, and I'm not sure what applicability that has to Arkansas Constitution. Did Georgia or Indiana require 2/3? Senate Bill 2 can be passed. I'm not saying it can't. I'm saying it takes 2/3. We can do a lot of things, but I'm saying it takes a 2/3 vote. In Georgia or Indiana, they have a similar provision which required a supermajority vote, and if they did those bills that amended their voting requirements, did they have such a requirement?
I think the answer to your question is no, but you're throwing in a bunch of things in your question which I think are not correct, and if you'll allow me to explain them, I'd like to. Because when we talk about the qualifications that are, the voter qualifications of Amendment 51, we're making a large mistake. But the voter qualifications are not in Amendment 51. The voter qualifications are in Article 3, Section 1. And so it's very easy to slide into this idea that, this Amendment 51 creates some new set or different set of voter qualifications. That is incorrect. The voter qualifications are laid out in Article 3, Section 1. SB2 is a measure that tests or measures those qualifications, and that's exactly why I explained those cases from other states. And the reason that I did that actually was to illustrate that there are sort of different theories here. As I said, between Representative Burris and the people who sat in here before, and the courts seem to go along, the majority of the courts seem to go along with Representative Burris's theories as to what establishes a qualification. So I think it's very important not to slide into this very loose and, to my mind, imprecise and incorrect way of speaking when we talk about the qualifications imposed by Amendment 51. That legally doesn't make a lot of sense.
Well, I guess we're using terms qualification very loosely. Under 51, if I want to go and register, I want to fill out a registration form. And what are my options as far as identification? What under 51? What can I show?
Well, under the current state of I'm almost to the point where I actually mentioned I mentioned to someone else here before that there's a person smarter than I am here in the audience, and when we're going to ask technical questions, we better have that other person come up. And I wonder.
Mr. Greenberg, you know what? I'm wallowing a possum, a hairless possum, hairless. Is that right? Okay.
It's a frightening thing to imagine, really.
Yeah, we don't do that in my neighborhoods. Okay. But I want to stop. You don't need to call anybody up. I think we're belaboring the point. I want and continue to have my members indulge me on this point. I think I made my point. Thank you.
Seeing no further questions from the committee, thank you, Mr. Greenberg. Representative Burris, you're recognized.
Thank you, Madam Chair. And since the matter at hand mostly deals with the transmission of a bill from the Senate to the House and the vote threshold that's required, with your permission, I'd like to ask Mr. Cook just a couple of quick questions.
That's fine. Mr. Cook, if you would please come state your name and who you're with for the record, and you're recognized.
Steve Cook, Chief Counsel for the State Senate.
Okay, thank you, Mr. Cook, for agreeing to take my question. The main issue at hand is the transmission of Senate Bill 2 to the House and the vote threshold that it took to transmit it. That was a simple majority, is that correct?
That's correct.
Okay. I borrowed Representative Lee's iPad and I looked up HB 1797 from the 2011 2011 general session. Basically exact same legislation. It passed the House with 53 votes in the 2011 session, requiring an ID vote. In your professional opinion, does 53 represent a simple majority or a supermajority of a 100-member body?
That's a 53 represents the majority vote in the House.
So I think it's fair to say that the bill that we passed in 2011 that was transmitted to the Senate on a simple majority vote, we are simply following the same precedent. I guess the Senate simply follow the same precedent that was set by the House in the 88th General Assembly to transmit a similar bill on a simple majority vote. But that's my point.
I thought it was properly before the Senate at that time.
Say that again?
I thought it was properly before the Senate at that time.
Okay, thank you very much, because I think establishing the precedent is pretty important in the discussion that we're having right now. So thank you. Thank you, Madam Chair.
Are there any questions? Mr. Williams, or Representative Williams, you're
Thank you, Madam Chair. I just can't be quiet. Mr. Cook, thank you for being here. If in the 88th General Assembly, if you made a mistake that you found out in the 89th General Assembly, would you try to correct that in the 89th?
I think the action that was taken last session, the action taken this session has been consistent with.
That wasn't my question. I said if you thought you made a mistake in the 80th General Assembly, would you try to correct it in the 89th?
Madam Chair, can I make a point?
I would say no.
I want
You would correct your mistake? Oh, you continue the mistake.
Representative
I want
Burns,
to be very
what's your
careful not
point?
to ask Mr. Cook a policy question, because that's not the goal. My goal was simply to establish the fact that the transmission made by the Senate was simply keeping a precedent with the transmission made by the House 2 years previous on the exact same legislation. I want to be very careful not to unfairly ask him about the policy that we have to determine. The only point is, we transmitted the exact same bill on the simple majority vote 2 years ago, and this session, the Senate followed the same actions based on the precedent that we set.
And since I'm a lawyer, I can't let him have the last word. You can sit down, so I'm going to question you, but to make the point, if we made a mistake in the 88, I don't think we should continue in that mistake in the 89 if it was truly a mistake. So what we did in the 88 may be at least instructive, but clearly is not conclusive of the answer to the question.
Representative Edwards, you're recognized.
I just had a question on the point of whether or not there was an objection on the Senate end at that time or not. 'Cause that's why we're here today.
Mr. Cook, if you could-
Objection.
There's none that I'm aware of.
Okay,
Thank you.
thank you. At this time, I'm going to ask Jessica Heston to come to the microphone, please. Oh, okay, okay. Okay, then we have no one else on the floor. Martha Adcock, if you would, please. And Representative Williams, I think you're making up for missing a few meetings there with all these questions. No, but I mean, the meetings you missed before. You would please state your name and who you're with for the record, and you're recognized.
Thank you, Madam Chair. My name is Martha Adcock, I'm General Counsel to the Secretary of State, and felt compelled to come up here to answer some of the questions in regards to Amendment 51, since that really is part of the purview of the Secretary of State's office. Amendment 51 was passed in following with the National Voter Registration Act, and that's what it's called. It was called Motor Voter, or NVRA, and that was the thrust of that federal legislation to make sure that there was consistency, somewhat consistency among the states, and also to make sure that folks weren't denied the right to vote, and that their registrations were not lost by the individual states. And that is still federal law. And so a lot of the requirements that you see in here, Arkansas happened to have passed that in an initiative. And so it was put to a vote of the people, and that's how it became here, was through that initiative process. There were some states that were exempt from passing that because they had no voter registration. So I cannot emphasize anymore as to whatever decision y'all make, it's your decision, but I just want to make sure y'all understand that how we view this and how the feds have viewed this and what we've done is that this is a mechanism for determining voter registration. Now, there were a couple of things that were mentioned in regards to whether or not it's permanent and whether or not you had to show utility bill, etc. So if you have your amendment with you, I'll draw you to Section 6 of Amendment 51. And one of the things you have to provide then under I and J, you have to have a current and valid driver's license or the last 4 digits of your Social Security. And that's what you put on your voter registration card. That then is submitted to the Secretary of State, and we spend money running through to make sure that those numbers are correct and that it is the person who you say it is, again, to avoid fraud, make sure somebody's not registering improperly, etc. There are exceptions in there under if you don't have the driver's license or you don't have a social security number, then the Secretary of State would have to have a communication with that individual and we would set a specific ID number for you. Now, this whole information about what do you do about bringing in a bill and a utility bill, and if you've been in House state agencies, we've been over this, so indulge me, I'm sorry if I've heard this before, but that specific requirement is in there for a first-time voter who registers by mail and does not provide either Social Security or driver's license. Then you are tagged within there, and that's then when you have to provide that ID. It's not something which says that everybody then has to do something and then provide the utility bill, etc. The utility bill is a very unique and follows a very small little group of voters over here. Those who registered by, the first-time voters, registered by mail and did not provide a social or the driver's license, which can then be confirmed electronically when we compare them against the systems that are there. Now, I will tell you, and again, your decision on the bill is your decision on the bill, but there's a specific provision in SB2 that maintains that. So we were careful not to change that specific provision for that first-time voter. So that is left there in SB2. Now, if you're looking at qualifications, and Mr. Greenberg talked about that specifically, and again, I just want to make sure y'all realize 51 is not a qualifications amendment, it's a registration amendment. Because if you want to know for a qualification of a voter, I'm going to again direct you then to the Arkansas Constitution and go to Article 3, Section 1, and that tells you what are the qualifications of electors. And under Article 3, Section 1, any person may vote in an election who is citizen, resident, 18 years of age, lawfully registered. So a violation of Amendment 51, I mean, they're just two different things. And I don't know how to, they're two different things. And then one other question that came up that we were asked in regards to if you're adding something to it, because it's not here in Amendment 51, but when you go to vote, what do you have to do? You may not have to, you may be asked for your ID, you don't have to do it, but do you have to sign? So what, so therefore is that, and again, I would say, if you don't sign, you must sign the book. Now there's an exception if you physically can't, okay? So there is something there for someone who physically can't sign. But if somebody just refuses, so there are things which adds to part of what some of the questions have been, are there requirements that are placed upon a voter on election day that then they must follow? And so there are some. But just because there were so many questions being raised, permanent registration. I know it says in there you're permanently registered, but say for example, you can not be permanently registered. The record is maintained, but you become a felon. You become a judge mentally incompetent. So again, you lose that, in terms of being registered to vote. And there are procedures specifically in Amendment 51, and that's really boring, but we'll go through it if y'all want to outside the committee. But if you fail to vote for a number of years, and again, this is provided, and all we do is track the federal law on this, is that you are not eligible as a voter. If you haven't voted in, say, 6 years or so, probably closer to 8, but you have not actively voted, I don't care if you haven't moved. You can be in the same house, same location, same county, same everything. If you don't, it's the whole process of keeping the voter rolls current. And so you may show up at the poll and you're not going to be on that roll. And then they may be able to call the clerk's office and they can tell by looking in the permanent voter registration record that you're on the record. So they may have a record there for you, but you are not a registered voter and you must complete a new voter registration application in order to become active again. So the reason they say it's permanent, and the whole idea of it being permanent, is the fact you don't have to register every time you want to vote. So I just want to provide those technical.
We have a few questions from the committee. Representative Clemmer, you're recognized. Okay. Representative Williams.
Thank you, Madam Chair. Ms. Adcock, question for you. In 1968, when Amendment 51 passed, did the state driver's license have a photo on it?
I honestly don't know.
Let me help
I
you.
honestly don't
Let me help you.
know.
It was 1979 when the state of Arkansas started putting a photo on our driver's license. So you could register, not be qualified, you could register with a social security card or a driver's license, which neither one has a photo. Is that correct? In 1968?
I'm going to assume you're correct on your facts because I have no reason to doubt you, sir.
All right, thank you.
I have no reason to doubt you on that one.
No further questions. Thank you. Members, at this time, we have no one else to signed up to speak forward yet, so I'm going to ask Representative Nichols to come back up to the table to close for his argument.
Thank you, Madam Chair. The one thing I'd like to respond to about Ms. Adcock that I'm confused about, and that is the first-time voter has certain things they have to provide, and a photo ID is not one that you have to provide as a first-time voter. So she said that they had mirrored that language from 51 in their act, but now you're also requiring a photo ID, which is not required for a first-time voter under Amendment 51. Anyway, I just wanted to respond to that part of Ms. Adcock's presentation. But this has been a very lively debate. I'll ask Ms. Boathammer to give some responses to close out our position.
I mean, I think that the issue before the committee is fairly simple, and it's whether this triggers the procedural requirements of Amendment 51. We've talked about registration versus actual voting and trying to distinguish the two, but I have problems understanding how, when I register to vote, I can provide either my photo ID or my water bill, and then I'm registered. And then when I show up to vote, why then I'm only required to, or I am required to just show one of those forms of identification. I think Representative Williams makes a really good point. If you're going to register with your utility bill, why should you have to, and then you are registered, you are then a qualified voter, why should you have to go to extra lengths to actually cast your ballot? Therefore, I think, I feel that SB2 is imposing an additional requirement in contradiction, or that's outside the explicit verbiage of Amendment 51, and therefore, in order to be enacted, it's going to require a 2/3 vote by each chamber.
Thank you, Madam Chair.
All right, members, I'm actually, given the issue at hand, I'm going to take this opportunity and mind the clock. It's 5 till, and you know we go into session at 1. But I'm going to open it up to the committee members if you want to at this time voice your thoughts or opinions on it, or open it up for discussion, if anyone would like to. Oh, Representative Williams.
Thank you, committee. Thank you, Madam Chair. I guess all I would say is a 2/3 vote is safe. If you look at this, we're not talking about whether you like the bill or not, but if it gets 2/3 vote, there's no question that what we're doing is constitutional. If it does not get 2/3 votes, there's clearly a question, and there clearly will be a lawsuit. So if it's passed with 2/3 votes, there's no question that it's constitutional. What we did will not send the state to legal fees and challenges. Thank you.
Thank you, Representative Williams. Representative Burris?
It's been very fun arguing against my friend Representative Williams. And I'm definitely cheaper by the hour in terms of legal counsel. But he does a very good job, and I guess as he expressed a closing, I'll do the same essentially. But it's just I think for us, the question is not about the merits of the bill or the content of the bill or anything else that can be discussed on the House floor if it's sent back. But to me, it's about the precedent. It is about the transmission of the bill and the threshold that it took to transmit. I think we heard varying legal interpretations from highly skilled and knowledgeable attorneys on both sides. I think anybody sitting here would have to admit that it is a gray area. So given the fact that it is gray, I'm very comfortable relying on the precedent of previous General Assemblies and the threshold that they used in transmitting legislation exactly the same. And again, I would refer to only 2 years ago on a bill exactly the same, which Representative Nichols voted for, that was transmitted to the Senate under a different speaker, under a different parliamentarian, under an entirely different set of circumstances, using only a simple majority vote threshold. Given the conflicting nature of testimony from attorneys here, I think it's very safe to rely on the precedent of previous legislatures and use the threshold to transmit this bill that they used to transmit previous bills that dealt with the same issue. Thank you.
Representative Edwards, you're recognized.
And I appreciate the references to precedent, but I just want to make sure I'm clear, and I think Mr. Cook, if I understood him correctly, if a precedent would be if someone had objected on the Senate end. So I want to make sure I'm clear, when it was transmitted from the House to the Senate last session, there was no objection to the transmittal. Right.
I believe that's what the testimony said, yes. Representative Gillum, you're recognized.
Thank you, Madam Chair. Just a motion at the proper time.
Seeing nothing else from the committee, Representative Gillum, you're recognized for your motion.
Thank you, Madam Chair. I move to recommend to the Speaker of the House that the Senate Bill 2 did receive the requisite number of votes to pass the Senate and is therefore properly in front of the House.
Committee, you've heard a motion. All in favor, say aye.
Aye.
Opposed, no.
No.
Representative Gillum, your motion carries.
Roll call.
No other business before the committee today.
Hey, man. How are you?
How you doing? Good. Good to see you. I didn't see you come in.
I snuck in there with this guy.
I got you. How easy?